So that would be an attorney, your general counsel, or if you have an attorney on retainer, however, wherever you get your legal advice. It's entirely appropriate to consult with as you build your process, as you make these decisions. Consult with your legal advisor. I've said that all along. Every company is different. You have different regulations. You live in different states. You're under different laws. You need to make sure that everything that you are building is legally sound and defensible. The same applies to the disciplinary phase. If you have certain contract or obligations or bargaining agreements, that sort of thing, make sure your disciplinary process fits within those requirements. You need to adhere to those as well. You can't step outside of those just because you want to. So as you're building this process, you have to take those into consideration. I have had organizations that have considered or wanted, I've talked to people that have wanted the attorneys to be more involved in the decision making. There are pros and cons to that. They definitely will understand the legal implications of the decision. They understand case law, especially if they are experts in employment law. But they are also the same people that will have to defend the company if there is a lawsuit, because there's never a guarantee. So you may want to consider having them as an advisor to the process rather than a part of it, rather than a participant, which will allow them to put them in a better place to defend it should that need arise, because they're not defending their own actions, they're defending the company, which is their job. So you may decide to have them be involved in the process, but consider that you may want to have them on the outside as a legal advisor that you use all the time, that is ready, that understands, that knows the policy, and can give very solid legal advice, but not to actually be on, say, the committee that is making the disciplinary decision. Make that decision how it works best within your organization and the rules and regulations that you are bound to follow. So of those different models of who could be the decision maker, the committee model is actually one that I would encourage you to look into, to consider. The reason, yes, it involves more people, so it requires you to train more people and to keep more people up to speed on the policy and the process. So there is some investment of time and training in this model. However, there are more pros than cons, I believe. So it spreads the responsibility of making a hard decision, because you might have to make a decision against disciplining an employee who is a favorite, who is a high performer, who is a leader, someone where it'd be very difficult for an individual to take some sort of harsh punitive action. Whereas in a committee, you can spread that responsibility amongst the committee. It can be easier for people to get on board with hard decisions. It allows for discussion. It allows for opposing opinions to say, no, I believe that's too harsh and here's why. So it opens up a thought process that can temper the extremes. One person may walk in and have some sort of personal bias or experience with that particular person or that type of misconduct, and they want to enact the harshest punishment possible, where someone else can walk in and have a different perspective and they can temper that and meet somewhere in the middle where it's more reasonable. So that's another great aspect of the committee model. You can also involve the business parties or teams that are impacted by this decision. So you may want to involve the employee supervisor or the division manager over that department, because they'll understand if we fire this person, what is our loss? Financially, what is it going to cost us to find someone else to hire them, to get them up to speed? They have kind of the impact on the business. They might also understand what it's been like for the complainant. So they may understand the impact on the complainant and what the different disciplinary options might do, or how that might help or hurt that. One model I've seen is it had permanent members on the committee. So the administrator over the policy was one of the permanent members. Maybe you have a union rep if you have union members. So maybe you have 2 or 3 permanent members, and then you invite their supervisor or the department chair or something as others. So as long as you have an odd number for the final vote. Or you just have a permanent committee that meets once a month and it's the same people. The issue with the flexible members is you do have to provide them training. So you have to say, okay, this month you have a person, you need to come to our disciplinary committee meeting. I need you to read up on the policy in advance, and then you have to read up on the investigation and the finding. So it is a lot of work for those flex members to get prepared for the meeting. And then once the decision is made, it's harder for the parties to argue bias or unfairness if there are multiple people from multiple different departments and perspectives who all agreed on a decision. Because you're tempering individual opinions or biases by doing the committee model. And then the vote would have to, you decide, does it have to be unanimous or does it have to just be a majority vote when it comes down to the final decision? So if you have the resources and manpower to do the committee model, that might be the way to go. It's something to look at. There are definitely pros to that model. So another consideration is, do you have a live hearing, or is this all just based, does the committee or the decision maker just read the reports? Is it all a paper review and decision, or do you actually allow the parties to come forward and give their arguments in kind of like a little court session? In the Title IX world, in higher education, that is the big discussion. And the Department of Education is looking at making hearings mandatory. There are pros and cons to those. So we are yet to see if those will work, if they will be mandated, and if so, what they will look like. They may work better in a higher education than they would in a private business. All sorts of different aspects and things to think about here. With a hearing, if this comes up when you're discussing your process and is an idea that you're floating, recognize that a hearing does take time, a lot more time. It's going to take a lot more resources. It will take people away from doing their day-to-day jobs for a longer period of time. But it does allow the complainant and respondent to give their side, the impact or mitigation statement, in person, which can be very impactful. So if you're unfamiliar with those terms, an impact statement is a statement that the complainant or victim makes describing how this incident, the misconduct, has impacted their life. In general, at work, emotionally, professionally, just what impact has it had on their life? Apart from the facts of the case, there has been there are lasting ramifications to misconduct, and this is what they are for me. A mitigation statement is a statement that the respondent or person found responsible would submit saying, okay, the facts say that I did it. There's a finding against me. However, I want you to consider all of these other factors about me personally, about the situation, what I was going through, everything else I've done for the company. These are the things that I want you to think about when you are making your decision, because I don't want to be defined specifically by this one act. So a hearing allows those things to happen in person. A hearing, it can be difficult because you're basically forcing the two parties to be together in the same room and to listen to the impact and mitigation statements that the other one is making, which are very personal, emotional statements. There's good and bad. The paper model, we're just making your decision based on the reports. The finding is already final. The investigator has already talked to these people. They've already gotten an opportunity to express their side in person to a representative in the process, to the investigator. So that opportunity has already happened. They've already had a chance to present witnesses and evidence and bring up issues that they think the investigator needs to look at. And the finding is done. So you're not rehearing the case. You already have a finding. You already have gone through the appeals process. This is in the court system, the sentencing phase. And the impact statement and mitigation statement can be made in writing, or it can be recorded and submitted via video. So you won't lose those statements just because you're going to a paper model. Takes less time, takes less resources. The members of the committee or your deciding body can read the reports when it's convenient, or they can work their schedule better that way. And at the end of the day, this is a business administrative process and therefore an administrative decision. Your misconduct policy is an administrative policy. This investigation, no matter how serious the misconduct is, at the end of the day, you are investigating a policy violation. So do you have a live hearing for other types of policy violations? You probably want to be consistent with how you handle those, whether it's misconduct or not.